Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. It's my pleasure to review another book from the Legal Action Group, the Access to Justice charity. This is a very important book, and it's a book that I do believe should be very much more widely available for everybody involved in the criminal justice process. It's called Defending Suspects at Police Stations, the Practitioner's Guide to Advice and Representation, now in the 7th edition, been edited by Ed Cape, as usual, with Jawed Luqmani added for a specific contribution. The book's available as a book and an e-book, and as I say, LAG are to be congratulated for continuing to produce these works. They are top quality, extremely helpful for any of us as practitioners, and I'm delighted to be able to review this book. I want to see this sort of book in every reference library in the country. It should certainly be in every police station and any police base, and it certainly should be much more widely available, mainly because we are in an era, whether we like it or not, where there are reduced funds available for legal aid and of any sort, and we have a population that hopefully is a little bit more highly educated than the past, which means that they should be able to identify very clearly what their rights are and the way in which the police should behave in the future. I'm not here to criticise police officers in any way, shape or form because we all have our jobs to do, but I think the most important thing to bear in mind with this particular book is that there are established rules and they must be adhered to. Now, that's the job. At the end of the day, it will be the job of the judge to decide what to include or exclude, depending on what's happened under PACE or the criminal justice legislation or whatever it might be. But we at least can see our way forward. Let's look at the book first of all. Ed has produced a really first-class book. It's a Practitioner's Guide to Advice and Representation. It's a heavy book. It's a paperback, and it's been around a while. I'm sure you've seen it. There's the spine, and then there is the back of the book. There's quite a lot of case law, and you can see the book split into two bits. There's the shaded bit, which is about halfway through, and that shaded bit is actually the appendices. It's extracts from the legislation and so forth, PACE and the Criminal Justice Public Order Act, the main ones. Let me go straight to the back first of all, because what we have got is we've got the index, which you can see there. Paragraph numbered, so you should be able to find it. The book is just under 1,000 pages long. There are some useful appendices. And if we go to the front, the appendices are obviously, as I say, almost half the book. Now, what Ed has done, this is the front page here. The book is available, if you go to the website, it's available also as an e-book. So there's no real excuse for getting access to these books. There is the information concerning the previous editions, and then there's the preface. Do read the preface because that sets out where we've come. Laws stated as at the 1st of May 2017, so it's a very new book. But what Ed has done is he's added explain what the newer points are in this current edition. Then we've got the contents section there. Then tables of cases, lots of cases of course. Then statutes, again, a large number of them. You should be able to find things. SI, statutory instruments, are also covered. And you should also, we've got some European legislation, which you can see there. Now, the European legislation is not going to go away, not at the moment anyway. So therefore, do be aware of the links that we have. And I do like the abbreviations. There's an awful lot. There's a big tendency these days to abbreviate lots of things. So it's useful to have the abbreviations. And then we get to the structure. This is very much the house style of Legal Action Group with the way that they structured the book. You've got a proper index right at the beginning, and it's paragraph numbered, and then you go straight into the actual body text. You can see the paragraph numbering is down on that side. It's on the right-hand side as you're as you're looking at it. It's on the left-hand side, but when I'm pointing, you can see I'm pointing with my right hand, but when you're looking at it, it's on the left. And you've obviously got a lot of footnotes. If we open the book up, advising the client, here we go. This is just dealing with what you can and can't do. Forget about what you see on television. This book is a much better way of trying to advise. For instance, the classic here, the failure to mention facts must occur no later than charge, for instance. And then again, what types of procedure apply in ID cases, identification procedures and so forth. So you've got a great deal. This is a book I think that would be of value to people doing the bar exams. We of course don't, as counsel, get involved in this side of matters, and I don't think we should be. That's for us to deal with in the court itself. But clearly this book is very much aimed at solicitors and advisors, and in a modern era, and I'm going to come on to that, we've got to start looking, I think we've got to have a very substantial sea change in the way we do our business, and that's going to be something I'm going to comment on. As I say, I think every police station should have a copy of this book, and the title, every police station, police base should have a copy of this excellent statement, is I think a very valid and it's not an expensive book at all, but it's something I think everybody should be aware of, and I certainly think the police should be aware of the book and what the powers are that they have, because sometimes they know what their powers are and they know what they do, and that's where the problems can start building up quite quickly. So what do we say about the book anyway? Elizabeth and I talked about it. Ed Cape's original purpose in writing this book, Defending Suspects at Police Stations, was to help criminal defence lawyers to be clear about their role at the police station and to give them the information, law, guidance, procedures, strategies to enable them to perform it effectively. So we're not here to get at the police, it's to make sure, the basic mission, make sure that correct procedures are at any given time adhered to, and that is, I suggest, in a liberal democracy, the best way to deal with it. Cape goes on to say that he hopes, despite the many challenges, that the book continues to fulfil its purpose as it does. Just that at a time when the role of the criminal lawyer remains often undervalued by those who want to be seen as tough on crime and others who have reduced spending on legal aid without apparently, says Cape, caring about the underlying values of respect, fairness and justice. Well, that's the big problem. It's not just confined to the criminal justice process, it's across the board. And the difficulty is that when you do that, you take that sort of decision, you should have some prescience as to what's going to happen. For instance, the classic is the number of people who are unrepresented, and it means that you will very quickly completely snow under all the courts because they can't cope. And that sort of problem has and could well continue to be a problem until we start looking at new ways of doing things. That means new technology, frankly. Well, any person who's practiced at the criminal justice within the criminal justice process will know exactly how much of an undervalue our work is, especially if you've been involved in the legal profession for nearly 50 years, as I have, and you've seen, as I have, the change. I actually go back to the period when we had quarter sessions and assizes, so I do remember the needs for change, the Courts Act and so forth, which is a long, long time ago. But there were needs for changes, but we've got to keep up to date. They've always tended to not really put very much money into this side of matters. And of course, if you don't, society will suffer as a whole. That's a logical argument, which is not necessarily supported by the people. Well, any person who's practiced, as I say, will have these views, and I think it's time for a change, but don't expect too much too soon. We've always drawn the short straw when it comes to our position in the legal scheme of things anyway on the criminal side, and I don't see things changing. The pay's bad. The system is not the best system in the world, but we're not dealing with very nice people quite often. So you've got to understand the difficulties. So if you're new to this work, the book and the functions, start by reading the preface. Ed begins with PACE, which he describes as being at the forefront of attempts around the world to ensure a fair pre-trial process, which he does, I think, and that the police are subject to the rule of law. Well, I can remember meeting a number of members of Parliament who were on the relevant committees when PACE was going through, and I did think this was a major piece of legislation, and I think it's been very, very good. But we've got to look again, certainly in this century, we'll have to start thinking again with the new technologies and the way Things are being done differently. We've got to think again about what we're doing. That's for the longer term, but certainly it's a time we started asking these questions, because there's no dispute, as I said, about what Ed Cape says about pace. Although it's very clear that these big changes I'm talking about have to be on the way this century, so that we can see a much more modern approach to the entire police process with AI and IT developments. That's artificial intelligence and information technology developments. We're still way behind, and we've got to do something about that quite quickly, I would suggest, especially with the type of offences that are now being committed, because the criminal justice code, if you like, the concept of criminal justice, is still not being reviewed and evaluated in a 21st century way. And I'm sure professors say this in the various universities, but we as practitioners see it too. And there is a problem. It's building up again at the moment, and it's something that must be addressed. Don't hold your breath. With a hung parliament, it's very unlikely much will be done immediately, but in the longer term we can look ahead. Of course, we all know that police systems have fallen incredibly behind other organisations with the way their business is conducted 3 decades on from pace, and we hope that, of course, more reform will be on the way. It did feature in the general election campaign. I wrote this review before the election, and I'm recording this after the election. A hung parliament, a wobbly that was thrown in right at the end of the election campaign was about police numbers and the cuts. So it will be a matter that will have to be addressed. Whether it's done by this minority government or another government, I have no idea, but it's certainly something that we should be talking about and seeing if we can get some positive conclusion. Meanwhile, we've seen piecemeal changes, of course, for things like fingerprinting, photographing, DNA sampling, plus bail changes and out-of-court disposals. Again, out-of-court disposals, very controversial in the Queen's speech, June 2017, very controversial, but it may be the way forward for some low-level offending. I don't know, but we'll have to see. No mention, of course, of guilty plea pressures that exist whether politicians accept it or not. And there always has been that. And, of course, legal aid has had its own little bit of pressure to bear on that too. Now, Cape's final important observation concerns the character of policing itself, and for applied criminologists with significant changes to the criminal justice process, it's an area, I think, which will be of great interest to people in the future. We then arrive at the crucial point of when Cape writes that globalization and technological developments have meant that crime and crime investigation have become more complex and more transnational. And that, of course, is the crossroad that we've now reached in 2017. And as I've said, we are going to have to make some decisions, but I think all bets are off as to what's going to happen for the foreseeable future. But I certainly think in the 2020s we'll have to revisit this. Now, the title remains the most important practical legwork for police, advisors and lawyers involved in the way we run our criminal justice code, as it becomes probably fully codified this century. And as I said, there's no criticism of the police. They're operating under a framework which has been established, and they do their jobs, I think, as well as they can in all the circumstances. But we've got to always be vigilant about the way in which we conduct our own business. So thank you, Ed, for your book. It should be in every police station and unit, and should be required reading, I think, for all involved in the criminal justice process, as we're going to face the biggest changes for years in the fourth industrial revolution. And are you up for the changes which are now must consider being imposed and taking place in the future? Because it's suddenly going to happen, and I can see it at the moment, and we are not as prepared as we should be. Let me conclude by saying you'll be, if you read this new edition, it's 1,000 pages, with these excellent annexes, you will, I think, be in a position to be prepared for the changes that take place. There will be no case to answer that the provision of good quality legal advice at police stations in England and Wales remains under threat as never before, at least once the government allocates proper resources for the work we do. And it may well be, after this what was a really difficult general election campaign in June 2017, the terrorist outrages, the problems, all the other problems, and what we've ended up with as a hung parliament, there will be light at the end of the tunnel, and that will be that hopefully proper resources will be put in eventually. But when, I don't know. The law is as stated on the 1st of May 2017, and it's available as a book and an e-book. Let's have one last look at it. There it is. There's the spine and there's the back. The book itself is quite interesting. This is Warrant of Further Detention. There we go. This is a big issue again. The way bail was organised and the way in which people were held during the Blair years and all the other years caused tremendous trouble within the criminal bar. Very grave concerns about what was happening, the decision to charge and afterwards and so forth. All that information very well covered here. It's a very practical book, and I think it sets out a very clear line between what we can do and what the police can do and the charging authorities can do. And I think we have to have that maintained as a constitutional propriety of the first importance for the future. I'd like to thank Ed very much, and of course must thank LAG. Without having these books we can't do the jobs properly these days. These books are very important. The reason I'm recording this is so that you've got some idea of what's available, and good luck with what you're doing. It's a difficult time. It's always difficult, this work anyway, but you'd make it a bit easier. So thank you to everybody concerned. Bye-bye.